Ready? Exercise number 2. Start. A brief history in regard to the levy of court fee deserves notice. Before arrival of British rule in India, there was no levy on the party approaching the court for redressal of its grievance. Historians say that during Mughal rule and prior thereto, there was no fee payable on administration of justice and it was totally free. With the advent of British rule in this country, regulations were framed imposing court fee and was nominal at the beginning. It was gradually increased to prevent institutions from frivolous and uncalled for litigations on an assumption that it shall act as deterrent to the abuse of the process of the court. Many do not feel that levy of fee had put restraint on frivolous and groundless litigations. However, in recent times, the scale of fee has been raised to an extent which has given rise to feeling to many that it is no longer a fee but tax on the litigants. Caveators say that in modern times, expenditure on administration of justice has tremendously increased, and therefore, in order to meet those expenditures, sharp increase in the court fee is the only answer. Without influenced by any of these considerations, we intend to consider the question involved on its own merit. Stop, next para. In fairness to Mr. Kunal Ravi Singh, appearing on behalf of the appellant, he does not contend that state legislature lacks competence to enact or make amendment in Court Fees Act. However, according to him, the power to legislate in respect of fee cannot be used to raise revenue of the state. It is contended that the amount of court fee realized is not spent for the administration of justice, and therefore the fee partakes the character of tax and hence it is ultra vires. Stop, next para. Mr. S.P. Kesarwani, however, appearing on behalf of the state, submits that the quid pro quo need not be established arithmetically, and if it is found that its object is not to raise revenue for the general purposes of the state, the act of the legislature cannot be said to be ultra vires. Stop, next para. Rival submissions necessitate examination of the constitutional scheme. Article 245 of the Constitution of India confers on the Parliament power to make laws for the whole or any part of the territory of India, and the legislature of the state for the whole or any part of the state. Article 246 of the Constitution gives exclusive power to the Parliament to make laws with respect to any of the matters enumerated in List 1 under bracket Union List bracket out, whereas the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters in list 2nd under bracket state list bracket out. In the 7th schedule, entry 3rd of state list gives the state legislature power to make laws inter alia in respect of fee taken in all courts except the Supreme Court. In view of aforesaid, there is no difficulty in holding that the state legislature has power to make law in respect of fee taken in all courts except the Supreme Court. Thank you very much. Guys, there is one humble request. Please always try to repeat the matter so that your fluency and accuracy will improve. And also there is one more request. If you found the matter is excellent, you can give your valuable comment on my YouTube channel. And also for next audio,